Guys, Tony DeWitt here, Missouri appellate attorney and a guy who enjoys answering questions here on YouTube. Today we're going to talk about the Chauvin trial. This is a follow-up to my earlier video about whether or not he got a fair trial. I think this video will pretty much conclude that he did not get one, so I'd invite you to stay tuned. So today we're going to talk about two issues. The first is a juror who may have perjured himself. He may have been untruthful in voir dire. Voir dire is the process of jury selection. And the other is going to be the effect on the jury of not being sequestered and being exposed to threats of violence against the city, which could easily be interpreted to be threats of violence against them. So let's get to that. The first thing I want to talk about is juror misconduct. Now, generally speaking, juror misconduct takes the form of jurors doing things they are told not to do, like listening to media or discussing cases with people they shouldn't be discussing it with. But what I want to talk about first is non-disclosure. Now, in voir dire, the first thing that happens is a jury is sworn and told to tell the truth, to answer the questions of the lawyers that are put to them fairly and honestly, and to give their true and stated purpose for their answers. Now, before they ever do that, they're given a questionnaire and they fill out that questionnaire, and that questionnaire forms the basis for some of the questions that they'll receive. And on the questionnaire, it tells them that they will be asked to affirm under oath that their answers are true and correct. This gentleman, his name I believe is Brandon Mitchell, did not say anything about having any prior connections to Black Lives Matter. And he said that he didn't know very much about the Chauvin case, that he had heard some general comments about it, I think, but that he hadn't reached any conclusions, words to that effect. And yet, that does not appear to be the situation. I want to steer you, first of all, to this picture, which is from a media outlet, and it says, "Revealed. Chauvin juror who promised judge impartiality now says people should join juries to spark some change and wore a BLM shirt in 2020. So we're going to switch now to the second picture, which shows this juror with a shirt that says, "Get your knees off our necks," and a hat which shows the words Black Lives Matter. This would not appear to be consistent with the answers that he gave during voir dire. In fact, they are completely inconsistent with the answers that he gave. In addition to that, he gave an interview on a program called Get Up, Mornings with Erica Campbell, on April 27th, where he said that people should say yes to jury duty as a means to promote societal change. I mean, it's important. If we want to see some change, we want to see some things going different, we got to into these avenues, get into these rooms to try to spark some change. He said jury duty is one of those things. Jury duty. Well, if he is trying to spark change through jury duty, I believe that's a pretty clear statement of his intent to mislead the judge with regard to impartiality. Because ideally, a juror going to sit on that trial doesn't have to know nothing about the case, but basically has to set aside what they do know and try the case only on the evidence. If you're trying to get on the jury, it would certainly seem to me that there is a presumption that you are attempting to affect the verdict. And then here is another photo which has perhaps an even better shot of the hat and the logo on the shirt that says, "Get your knee off our necks." And it says in a Facebook post, his uncle posted this picture, and you can see the BLM hat as well as the logo on the shirt. So What does Minnesota law say about juror misconduct? Well, here's a quotation from a case. The purpose of a Schwartz hearing, okay, and that's the hearing that will be held in Chauvin's case, is to investigate potential juror misconduct and prevent the practice of attorneys from contacting and questioning jurors about a verdict after it's been rendered. Such a hearing also allows the losing party to establish a record that might indicate juror misconduct. And then it says the trial court has a great degree of discretion on whether to grant a new trial based on evidence of juror misconduct. So here's the second thing that Minnesota law says. It says inquiry into the validity of verdict or indictment. You can't ask about jury deliberations. It says that. But down here it says except that a juror may testify on the question whether extraneous prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought to bear upon any juror or as to any threats of violence or violent acts brought to bear on jurors from whatever source to reach a verdict. I think that's very important language, from any source to reach a verdict. And then here's what the Minnesota courts say about this particular issue in a criminal case. In a criminal case, any private communication, contact, or tampering, directly or indirectly, so calling the juror or posting information and saying things in a public forum that you know will get back to a juror, with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial. While a presumption is not conclusive, the burden is on the government to show that the error was harmless. And in this case, I don't believe that that's going to be the case. So what will happen? The judge is going to be called upon to do a Schwartz hearing, and not to decide and take final action on the information, but rather determine for the circumstances the impact thereof upon the juror and whether or not it was prejudicial in a hearing with all interested parties permitted to participate. So that's what is going to happen in this case. The jury, particularly the first juror who said that the jury felt threatened, is probably going to be called to testify. And she'll be called to testify about what she heard, the things that were said to her, the things that they believed that other jurors had heard. Those are things that don't go to the jury's deliberations. They go to the information that was given to the jury or shared with the jury in one form or another. And then the other thing that will happen is that this juror, Brandon Mitchell, will be called upon to testify, and he'll be examined directly as to whether or not he violated his oath. And his answers are not going to be dispositive. In other words, if he says, no, I went into this with a completely open mind, then he has to account for why he didn't mention the BLM hat, why he didn't mention the George Floyd shirt, why he didn't talk about going to a protest because there was a question in the questionnaire directly about the protest. Why didn't he do these things? In short, if this were any other case, were just a private defendant other than Mr. Chauvin, if we're talking about a notorious murderer even, who took out a gun and shot 6 people, he would be entitled to a new trial under these circumstances, simply because the prejudicial effect meant that the trial itself was not fair. It's a structural unfairness. You have tilted the jury one way with threats of violence against them, and the jury simply can't make a clear deliberation free of that. How does a juror who knows, for example, that a severed pig's head was left at the home of one of the defense witnesses feel about that? Do they worry about whether or not a severed pig's head will be left on their doorstep, or if something worse will be done to them? Because almost all of those jurors know that there are numerous people who know their names, and that they can probably find other information about them. So that's my thought process with regard to the Chauvin verdict. I don't necessarily disagree with people who say that he's guilty of something. I think it's an open question, and I think that reasonable minds could disagree about whether or not he committed a crime. I certainly think that there was a delay in getting him medical treatment, but that may simply be civil negligence. And the Floyd family has been well compensated for any negligence on the police department's part. So those are my thoughts. I hope you found them interesting and perhaps insightful. I've given you a little bit of law to think about. The law is pretty clear here. And whether you like that law or not, it needs to be followed. Because once you start treating one category of defendants differently than you treat other categories of defendants, you have a two-tiered justice system. And that is a recipe for disaster. If you enjoyed this video, please like and subscribe. And I hope that you'll have a chance to see our next video, which you will if you subscribe and touch the subscribe icon and the notification bell. And if you'll do that, I'll see you on the next one. Thanks.